Today, the Supreme Court heard oral arguments in what is likely to be one of the most consequential and most watched cases of the term. Question: does federal civil rights law allow employers to fire people solely for the infraction of being gay, lesbian, or transgender? Now, it is clearly against the law to fire someone because of their gender. Title VII of the Civil Rights Act made that illegal. You can't, for instance, tell a high school's history teacher he is fired because he's a man, or tell a female hospital administrator, thank you very much for your service, but we want a man in this job. Can't do it. Right now, it is an open question as to whether you can do that to gay, lesbian, and trans folks. Today at oral arguments, the ACLU and others, on behalf of the several clients fired explicitly for their orientation or gender identity, argued that protections against sex discrimination also must logically include protections from LGBT discrimination. And on the other side of that argument, well, the Trump Department of Justice, arguing that federal law says it's completely fine to fire people because they're gay, lesbian, or transgender. The federal law just doesn't have anything to say about it. Joining me now to talk about what this means for a Supreme Court that is quite different from the one that legalized same-sex marriage 4 years ago, Rita Tabacco Marr. She's senior staff attorney with the ACLU's Lesbian, Gay, Bisexual, Transgender, and HIV Project, and who is on the team that presented oral arguments today for one of the plaintiffs. Good to have you here.
Thanks for having me, Chris.
All right, maybe start with you represent one of the plaintiffs, Amy Stevens. Tell us her story as a way of setting up what the question is here.
Sure. So Amy Stevens was a valued employee. She worked for 6 years as a funeral director and embalmer at a funeral home in Michigan. After that time, Amy realized she could no longer hide who she was. She had known since she was a young girl that she's a woman, and she spent many months carefully crafting a letter to her boss, letting her know that she is, in fact, a transgender woman, and she would be returning to work after vacation as her true self, Amy. And when her boss received that letter, 2 weeks later, she was fired, told, your services are no longer needed. The reason? The fact that Amy, an employee he had believed to be a man, was in fact a transgender woman.
The government's argument today before the court, not through the appellate, is that that's fine. That whatever you think about it personally, that like federal civil rights law and particularly protections against sex discrimination at work simply don't apply to Amy or don't apply to folks that tell their bosses they're gay or lesbian and get fired for it.
That's exactly right. And I think the Trump administration's position in this case is so shocking for a number of reasons. The first of it is that the federal government actually filed Amy's case under the Obama administration. It was the federal government that filed this lawsuit on Amy's behalf. Now the Trump administration is switching sides and throwing Amy under the bus.
So DOJ was filing the lawsuit on Amy's behalf, saying that the federal law doesn't allow you to do this. And then Trump came in and switched the sides of the DOJ.
Exactly. So the DOJ and the Equal Opportunity Employment Commission, which was the agency that originally filed, but DOJ was right there with them, agreed that Title VII protects workers who are fired simply because they're transgender. Now they've switched sides, essentially making a series of arguments that I think did not work very well today. So for their first argument is essentially it's fine if we fire transgender women as long as we also fire transgender men. Somehow this idea,
this is their equality. Yeah. The equality idea is that like you can't discriminate, but you can fire them all.
Yes, exactly. I think, any kindergarten can tell you 2 wrongs don't make a right. But there's also a reason this doesn't work as a matter of law. And that's because if you think about what it means to be transgender, it's inherently based on the person's sex. The very definition of what it is to be transgender is someone whose gender identity is different from the sex they were assigned at birth. So it's just impossible to fire someone for being transgender without taking into account their sex. One of the very qualities that Congress said in 1964 should be wholly irrelevant to our opportunity to succeed at work.
There's a case in 1989, I think, with PricewaterhouseCoopers, which is a really interesting case in which essentially I think a female employee is told to like femme it up, basically like you should wear lipstick and skirts and like act more feminine or you'll be fired. And she takes that all the way to the Supreme Court. And what does the Supreme Court say about that back in 89?
So in 89, I mean, you're sort of, pantomiming it up. But in fact, the actual words told to Ann Hopkins, she was told to walk more femininely, talk more femininely, have her hair styled, wear makeup, and take a course in charm school, which is unthinkable today that an employer would actually take that argument to court and say, hey, what we did here is perfectly fine.
And allowed by federal law and Title VII.
And the employer's argument in that case was, look, it wasn't the fact that Ann Hopkins was a woman. She was the wrong kind of woman, right? It's not her sex. It's these other traits. And what the Supreme Court said in 1989 is those traits go to the very heart of our expectations about what it is to be a woman, right? If we can be fired for not being the right kind of woman, then our protections against sex discrimination really are meaning-less.
What do you say to people that say, okay, I mean, this is what's called a statutory interpretation case because what you're arguing over what the meaning of a federal law, the Civil Rights Act, Title VII means. People say, look, I'm with you on this, but you should just pass legislative protection. Like you can add into Title VII, you could just add gay, lesbian, and transgender into the law.
Yeah, so that's really the Trump administration's second argument. And I think the answer there is, right, Congress has already prohibited this form of discrimination because when you look at the words of the statute, just the words of the statute, because of such individual sex, it's impossible to describe what happened to Amy without taking into account her sex.
Right. It makes no sense otherwise.
Exactly. And the Trump administration is essentially trying to go outside the words of the statute and say, hey, let's think about what Congress was doing in 1964. And the response to that is, right, we don't try to read Congress's mind. We look at the law that Congress actually passed and the words they used.
Final question. How big are the stakes for gay, lesbian, and transgender employees and workers in this country?
The stakes could not be higher. This goes to our very freedom to work, to support our families, to keep a roof over our head. 1 in 4 LGBTQ workers say they've experienced discrimination at work in the last year alone. So this goes to the very heart of what it means to live and work in this country. All
right, Rita Tabak-Omar. Well, you made a very good case here. I wish I was the Supreme Court. It's good to have you.
Thanks for having me.
Hey there, I'm Chris Hayes from MSNBC. Thanks for watching MSNBC on YouTube. If you want to keep up to date with the videos we're putting out, you can click subscribe just below me or click over on this list to see lots of other great videos.